Okay. Good morning. This is Senate Judiciary Committee, January 29th, almost the end of the month of January. It's a cold, cold morning down here in Bennington. I'm sure it's even colder up in the kingdom. But welcome to Senate Judiciary. This morning's bill that we're taking up is S45, an act relating to earned discharge from probation. I'm not sure the title is as apt as it could be about what we're really trying to do here. But we're going to first hear from Bryn Hare. I will announce that Senator, many of us had connectivity issues this morning getting on, and that's why we're a couple of minutes late. But I will announce that Senator White is still having connectivity issues. So, Bryn, why don't you take us through a kind of a quick walkthrough of the bill, since we already actually heard testimony on the genesis of the
bill. Sure thing. So good morning, committee. For the record, Bryn Hare from Legislative Council. And you did get a walkthrough of the draft of this bill before it was assigned a bill number last week. So I know you have a whole bunch of witnesses this morning, so I don't want to be repetitive, but I will do a quick summary of what the bill does. There are a couple of changes from the version that you walked through last week, but nothing really major. Just some reorganization and some tweaks to the wording based on some of the testimony that you heard from witnesses. So Section 1 is the duration of probation section of law, and this is a directive to the courts. Does everyone have this bill, or would you like me to put it up on the screen?
Why don't you put it up on the screen? I didn't print out the new copies.
Is it the version that's introduced or a different one?
This is
as introduced.
S45.
Thank you.
Okay, just give me a minute and I'll pull it up here. Everybody see that?
Nope.
Okay, so you'll remember Section 1, this is the directive to the courts that provides that the sentencing court that places a person on probation can discharge that probation and terminate the remainder if it's warranted by the conduct of the offender. That's current law. And what is added here is a directive to the court that says if the Department of Corrections recommends that a person's the probationer's period of probation be terminated and discharged prior to the end of that person's term, or if they recommend a deduction to the remainder of a person's term, if the court has to discharge or follow that recommendation unless it finds by clear and convincing evidence that discharge isn't in the best interest of the person, or that discharge of the person will result in a risk of danger to the victim or to the community. And it also provides a specific directive that the court has to set forth the reasons for denial of the motion on the record. And then subsection C, this is the language that was the version you looked at, it was in section 2. We've moved it up here to section 1 because it really is it's a more relevant in section 1 here as a directive to the courts that probationers aren't deemed ineligible for discharge or a term reduction if they're due to unpaid restitution, fees, or surcharges. And I just wanted to, I'm sure the committee remembers, to flag that part for you. There was some discussion about whether that should apply to restitution or not. I think you're going to hear some testimony today about that question there.
Right.
So section 2, the conditions of probation. This now is the section of law that really is providing directives to the Department of Corrections. So the changes here are that we've added some subdivision headings. And I'm going to scroll all the way down to the new language, which is here at the top of page 6. Review and recommendation for discharge. So this subdivision D here, an existing law provides that the commissioner has to actually may file a motion requesting that the court discharge a person at the midpoint of their probation sentence. And so the changes here make it presumptive. So it provides that the commissioner shall file that motion requesting a dismissal of the remainder of a person's term if certain criteria are met, and those criteria are found here in subdivisions A and B. If the person has not violated the conditions of their probation in the 6 months prior to that midpoint review, and the person is participating in the case plan. And I want to flag this for you all too. There was some discussion about this language, participating in the case plan, whether that language was appropriate or not. So I'm sure you'll hear more about that from the witnesses.
That's where it used to say actively participating?
Correct.
It-
And we removed the
You took
word
the
actively.
word actively out. Okay.
And then subdivision 2 provides that if that probationer isn't eligible for discharge after the midpoint review, because they didn't meet those criteria perhaps, it allows that the department may file a motion to request a deduction of a portion of the remainder of the probation term if the person has conditions completed or goals attained. Subdivision 3 provides that if after the midpoint review, no motion was filed, it requires that the commissioner continue to conduct a review each 6 months following that midpoint review. And again, we have the same language here. If the probationer meets those criteria that were outlined above, that they haven't violated in the 6 months prior to the review, and they are compliant with their case plan, then the commissioner shall file a motion to dismiss the remainder of the term. And if they're ineligible for dismissal, the commissioner may file a motion requesting the court deduct a portion of that remaining term. So exact same language, 6 months later at each 6 months review following the midpoint review. And that language
Bryn,
itself.
hey, Bryn, can I
Yep.
stop you a second? The phrase, you can have to scroll up about a half a page if you would. Okay, right there. It's completed conditions or attained goals. So if there is conditions they have not completed, they could still be eligible because they've attained some goals that aren't defined.
Yes, that's how I read that language. And I would just point out that there is existing, this is existing language. We've repeated it here, but
Okay.
under current law, the commissioner may file this motion.
Yeah, all right. If they've
requesting-
got if they have a history with this, and I'm not going to get too picky about it.
I'm just wondering if I'm understanding it right. We're talking about previously articulated goals, right? They can't, the would-be probationer can't say, well, I had a personal goal to do 100 push-ups a day and I completed that. We're talking about official goals, right?
Yes, and I suspect you're going to get some helpful information from the witnesses today about this, because I think it sort of dovetails with the question about whether compliance with the case plan is the right way to articulate that eligibility criteria. I imagine that these goals and conditions are a part of the case plan, if that's the right word to use.
Okay.
So it may be that you want to get more specific about what that means to attain goals or complete conditions.
Yeah, because as it stands, it's pretty loosey-goosey.
Okay, I'm going to move on to section 3 now. And this is the directive to the Department of Corrections to gather some information about how this midpoint review process is working and report back to the Justice Oversight Committee in August of 2022 and 2023. And specifically, this is the data that they're required to collect: number of probation discharge or term reductions that are filed by the department, and then the number of probation terms that actually were reduced or terminated, and the amount of time reduced from probation terms as a result of these motions granted by the court. And then it takes effect in July of this year, and that's it.
Great. Thank you very much. That's helpful. received a request from several witnesses to have Dale Cook go first, who is scheduled later this morning. I assume Monica would join Dale, and if she is available or wants to. I don't see her on the screen, so she may not be here yet.
He's not here today, sir.
Oh, okay. She won't be here then. That's fine. I'm sure you can handle it.
Hopefully.
So we'll start with Dale and then go backwards to the original order.
Well, good morning. For the record, my name is Dale Crook. I am the Director of Field Services for the Vermont Department of Corrections. Today we're talking about S45. I'll kind of walk through it. I'm not sure if some of the language here is a little clunky, and I'm not sure it fits in how things, what the committee or what the Justice Reinvestment was kind of looking at. I was kind of involved with some of those committees. So I'll try to read through it and give you our feedback and some suggestions. The first section 1, we're fine with. One thing I will want to talk later about is about the partial reduction of term. In reality, it doesn't really work that well when it's implemented. We kind of have certain language like that now, and it just gets clunky, and I'll explain that a little bit later. The rest of this of section 1, B, we have really no other issues with. There may be a concern about the courts making the determination if it's in the best interest of the person or the risk to the public, which I'm assuming Judge Gerson will be able to talk about. Section C is fine. We currently don't hold individuals on for failure to make payments. That's kind of current practice. That's for section 1. Now there's just some kind of cleanup language, and we'll get kind of to the meat of the changes, which will be on the top of page 6. The first change in number 1, you need to have to make a determination on is the may to shall, and the shall is fine, but just to make the committee aware that the way the language is written now, sex offenders and domestic violence offenders would be included in this. I'm not saying if that is the intent or not, but the way I would read this is that sex offenders would currently be eligible for this, and there could be conflicting language with Act 1 from 2009, I believe is when it came out, around the department's responsibility with supervising sex offenders. If it's the intent of the committee to exclude sex offenders or any other offense-based individuals, I would just add that language in there or not. It's really a policy decision to include them or not. So that's with the shall and the may. We have a rule right now with the may, and in our rule, we exclude sex offenders and domestic violence offenders and behaviors that are in affidavits that could be constituted as domestic violence or sexual violence currently. Moving down to...
Are those sorry, Dale, are those the folks that are on lifetime supervision for sex offenses? Or are they just purely probation?
What was that question again, sir? I didn't quite hear everything.
Are the ones who, the sex offenders who are on probation, are they on for a lifetime probation period?
It depends. It depends if there's a term on the probation order, if it would or would not. If it's until further order of the court, they would be on. The department would not recommend a discharge for a sex offender. The criteria in Act 1 was unattainable in our opinion, and I think it was overwhelming evidence is our criteria, and we have been able to determine that. But offenders can't petition the court for discharge on their own. It's just that the department will not make that stance. but it really depends on what the probation is. But I assume some others that follow me can probably better explain. Not all offenses will be given a term. There are a lot of serious offenses where they're put on probation can have until further order of the court. They just have to be able to the courts just have to justify why they're not going with the term sentence.
What? Yeah, I'm just trying to understand, but we'll hear from the victims groups. But I'm trying to understand if we were making certain groups not eligible, it would be those that are on probation until further order of the court. Because would
They
that
don't have
be
a specific term.
because they don't have a specific term? Those that are, this is designed for those who are have a, you know,
A midpoint.
a midpoint of say a 5 years. So after 2.5 years, you would hold this midpoint. I don't know how you do a midpoint until further order of the court.
We don't. The language currently is for a specified term. So the offender has to have a term of probation.
Well, I guess I'm asking, do we need to be clear about that? And welcome, Senator White. Do we need to be clear about that?
Well, as it's written now, sex offenders, domestic violence, all offenders with a term probated case are eligible for this. If that's the intent, then that's the intent. If it's not, I'm just making you aware. I'm not arguing either side. I'm just saying that may to shall is all right. An important piece.
I appreciate that, but I guess what I'm trying to get at is those with probation until further order of the court would not be eligible.
Correct. That does not apply to them.
No matter what the offense, as the way it's currently written, anyone with a term probation, 2 years, 3 years, 10 years, 20 years would be eligible at the midpoint.
Correct.
So if somebody's, say, had a 20-year probation, I don't know, did they get a 20-year probation term?
They can be, yeah.
Yeah, so after 10 years,
If
do we review them anyway? I mean, under current law, do you have a midpoint review after 10 years? If they had a 20 years?
it wouldn't, if they would have a term, we would, and currently, unless they're sex offenders, we wouldn't. But they would have to have a term. So if they don't have a term, this does not apply to them.
Okay. Thank you for that. We'll wait for some witnesses to give us more thoughts on the issue, but thanks for the
Okay. The next section, the section A about has not been found in violation of conditions. That's fine. B starts getting into language that's not really applicable for probation. Really, with probation, the understanding is that the probation conditions are really kind of drive everything. The case plans don't really drive probation conditions. So having a case plan, we could have things in the case plan that aren't connected to the probation conditions, and we would have no authority to, as a department, to have the offender complete those requirements in the case plan. I would make a suggestion that B would be changed into instead of participating, successfully completing the conditions of probation. That's kind of what the judge set forth through the agreements is here are the conditions of probation that the offender needs to complete in order to satisfy his probation requirements. That's, I think, cleaner in our opinion. And of course, you can hear from others behind me.
Dale,
Senator Baruch, yeah, go ahead.
would it be completing the conditions or currently complying?
I would recommend completing. Just complying, they may not be completing with their risk reduction programming. Some programs may take longer than what's at the midpoint. If someone has for example, some of our sex offender programs can be 2 years. If after halfway through they're completing, I don't know if it would be in the best interest to discharge them before completing treatment.
Well, maybe it's a semantic thing. I thought that conditions were ongoing while you were on probation.
Correct.
So at the midpoint, you wouldn't have completed them. You would be in current compliance with them. You see my point?
Yes, but we have the standard conditions to allow for the supervision of the offender, the special conditions of probation.
What about satisfied? Has satisfied?
That's fine as well, as far as I'm concerned.
Yeah,
Okay.
Satisfied or completed the conditions
Because completed makes it sound like they're done and in the past, but actually they're still in force.
correct.
And I have a hard time with the word successfully. That's in the eye of the beholder, really. I used to have kids and we questioned, did they successfully complete the program? Whatever that means. They attained everything they could get out of that program. But what success to me and you might not be success to somebody else. I think that's a really tough term to put in there, requiring successful completion. I mean, unless you can unless you can figure. I had a boss one time who told me you can't determine whether somebody was successful until their life is over. And he worked for the Department of Corrections, by the way. So at any rate, I think we might want to avoid that term as well. I think the idea of Senator Baruth.
No, I don't think we would object to that. I think what we're indicating is that case plan it really should be driven around probation conditions.
Conditions,
and however level of satisfying or completing that the committee thinks is appropriate. Case plan I don't think is a workable component here in practice.
Senator Bennett.
So Dale, why attach the phrase probation conditions or attained goals?
I think some of that was old language. So the department's authority is driven through the probation conditions. So they could have goals, but the department can't enforce them. We can only do what's on the conditions of probation.
Well, that's what I'm thinking. But if you have, let's say probation says, well, we don't like you leaving probation until you've found adequate housing. But adequate housing is not one of the probation conditions. So you've got this internal goal or desire that could be in conflict with what we're trying to accomplish here. Am I correct in saying we probably ought to jettison that phrase or attain goals?
Yes, I would agree with that. I would focus the language on probation conditions, because that's really with probation, they are under the authority of the court and the department that supervises them. Those conditions is what drives everything with a probationer. It drives discharge, it drives violation, it drives completion dates. Everything is driven by the conditions of probation. Goals, case plans, those are things that our probation officers will work with, but we don't really have, as far as casework and social work and helping individuals be better themselves, but it's something we don't really have the authority to impose upon an offender.
Okay, thanks.
Could you, so if one of the conditions of probation is that they work with both rehab to get a job, or the Department of Labor, that's a condition of probation, not a goal that they have a job. Am I correct?
Correct. Now, it doesn't mean that goals can't, or conditions can't be kind of geared around goals. It's really what is set in the probation orders. And we'll have goals to help accomplish, we'll set goals, we call them supervision plans, which are really how an offender will accomplish his probation conditions. And it may be your goal is to go get an assessment by the end of the month and then follow the recommendations. That could be a goal internally, but it's not but the condition is what drives that goal. The conditions of getting an assessment on a probation order is what drives.
Senator White is now connected and wants to ask a question.
I am. I had to come up to the State House. I have no idea what happened to the internet at the house. But
Probably didn't pay the bill.
No, I did exactly what they said too. She left a note and said disconnect it and then connect it. And anyway, so I just wanted to follow up on Senator Sears' question there about the finishing. If one of the conditions is to work toward a high school diploma or a college degree or whatever it is, or a GED, that successfully complete, or not successfully, but satisfying that means you're continuing to work toward it. Doesn't mean you've got the GED or the high school diploma. Am I right about that? Because it doesn't say have one, it says work toward.
It really depends on what the language is written down. So if it says to be engaged in educational services, someone engaged in educational services at the midpoint, we would, at least I would interpret that as satisfying that condition. Are there in compliance with that condition at that time? Okay, thanks. I just wondered. If the language was more specific, must obtain a high school diploma, then they would have to obtain the high school diploma to satisfy that condition. Yeah, and the same with working with folk rehab toward getting a job or training or whatever it is. Okay, thanks.
Okay, why don't we move right along, Dale?
So now we're up to 2. This one of the suggestions reading this is I would recommend removing the partial credit, especially with.
Where's that?
It kind of flows down a little bit farther because we have the conditions and goals. It's not in section 2 actually. I'll continue. I'm sorry, my mistake. But with this, I think
it's the next page at the top.
Yeah, with the goals and stuff, I think we've discussed that. That is really driven by the conditions of probation. Now, following the midpoint and number 3, that is fine. Where I think there would be the partial reduction of term, especially with how I think where this language is moving toward, makes it it doesn't work well, because if an individual, and I'll give an example, someone has a 1-year probated term and they have 4 conditions to satisfy. At the midpoint, they have 3 out of the 4 done. So we'd reduce, let's say, 25%, which would be 3 months. If the offender in that 3 months doesn't complete that 4th condition, we would have to violate his probation in order to extend the condition. So it's kind of like this, like it could put us in a situation where it wouldn't be very beneficial. It's a lot of paperwork going back and forth between the courts. You have this 6-month review. I would actually make a suggestion that after the midpoint review, anytime the offender satisfies his conditions of probation, the department shall recommend a discharge.
Actually, the CSG suggestion was a shorter term period, and I said 6 months just to avoid hassle for you all. But if you're willing to do it that way, I think that's okay. Bryn and I talked about this as the bill was getting drafted, and I thought it would be simpler for you at a 6-month period, but to not have somebody coming in all over the place.
No, because we have most of these cases are going to be on administrative probation, going to be on low risk. Right. And we have an automated system that actually would work really well with completing this. So once
many of them are just do not. If you get arrested, give us a call. That's the only condition, right?
On some, there's usually conditions. Very rarely do we have administrative probation, where we have a telephone monitoring system that is actually would work really well with this, because once things are completed, we can have the system flag it and do it. Otherwise, with the high risk, they're meeting with their probation officer at least once a month, if not more, driving for those goals.
I get one other question about this section.
Mhm.
Over the years, in working with young people, sometimes the goals or the conditions set at the beginning are not realistic as you get to know the person better and as you get to realize. So using the example Senator White gave, maybe this person just isn't capable of getting a GED. That may actually be true. And so you would revise then that. You can't revise the condition, but how would you deal with that if you went back to court?
We could, depends on how the language is written. A lot of the language is written to the satisfaction of the probation officer.
Yep.
So that gives discretion. So if an offender is not able to reach the job or whatever it may be, they may be able to do something else that
Right.
satisfies that condition because the offender is just not capable of doing that. Is one way around. We can also file a motion to modify conditions with the consent of the offender. So if the offender believes that this condition needs to be modified, we can do that.
You don't have the standard conditions anymore, do you?
There are still some standard conditions.
Thought the Supreme Court had ruled that you were limited in that.
There are a handful of conditions that allow the department to supervise, but all special conditions should be geared toward either risk reduction or the crime itself. I see Matt Valerio popped on. He can probably explain it a lot better than I can. But
Well, I was thinking of, you shall not consume alcohol. You're 35 years old, have never had a problem with alcohol, but that was a standard condition. You can't apply that condition. That was my understanding of the Supreme Court rule.
correct. It has to be connected to the crime or to rehabilitation or for supervision.
Are there other things, Dale, that you have issues with?
No, just I talked about the partial reduction. The rule section 4. I'm not sure. Depends on how the language plays out. I'm not sure if a rule is necessary. With shalls and pretty specific language in statute, a rule may not be necessary. If the committee continues and wants the rule, we would have to do emergency rules because we would never be able to get to the rulemaking process by July 1. I think without the rule, we'd be able to. This is pretty straightforward. It's not really a huge lift for the department as far as it's just some policy work. It's not implementing, a whole bunch of other components within the department. The report parts is fine. I spoke with Monica yesterday. No issues with the reports and the data and the tracking of the data. Any other questions for me? That kind of covers my thoughts. I'll be on if there's other questions if needed.
I don't have any. Anybody have any others? Very good. Thank you, Dale. Appreciate it. I'm going to go back to the original order unless there's somebody who would rather have it changed, which would be David Scher of the Attorney General's office.
Good morning, committee. For the record,
Morning, David.
Scher. Morning, Senator. For the record, David Scher with the Vermont Attorney General's office. The Vermont Attorney General's office certainly supports this legislation in concept, and we are fine with working with other stakeholders to tweak it a little bit to make sure we get it right. As the committee may remember, this is sort of stemming from, this is the replacement idea for the idea that we grappled with a little bit last session around having probation, the underlying time on somebody's sentence run while they were serving probation. That proved to be complicated and had some concerns from various stakeholders, and this is the, I would say, the replacement option that has come out of the Council on State Governments. And we think it's a reasonable replacement and support it. I think that there's a couple points I wanted to mention and happy to answer questions, although I think other stakeholders will have will go into some of this stuff in more detail than I will. So I'll keep my remarks relatively concise. One thing that the committee was already getting at was in your discussion with Mr. Crook, was that how do you decide what a satisfactory completion looks like, or satisfactory participation? What does that mean? What does that look like? I think as a general matter, the law should be phrased to make it clear that somebody who is actively participating and obeying the conditions should, generally speaking, be recommended for discharge. There's a big caveat, an important caveat to that, which is that people who are in the middle of a program, like the programming that's done for sex offenders, for example, those programs, this should be designed in a way that people are required to complete those programs. So programs that essentially have a set course, a set time, conditions, in other words, that are not conditions that you just have to meet throughout the term of your probation, but conditions that that require you to complete a curriculum. I think that it is reasonable to have those be required to be completed before discharge happens. And this was actually one of the main concerns. I don't want to mischaracterize it, and Attorney Pepper can correct me where I'm wrong, but I believe that this was actually one of the main concerns that state's attorneys had with the prior idea around time running. While somebody was on probation, they were concerned that if somebody didn't finish required programming, like the programming for sex offenders, that there would be no way to force that completion. And so I wouldn't want us to run into a similar problem here. And I think that can be accomplished by tweaking the language. And I'm not sure if Attorney Pepper or others have specific suggestions. I'm still, to be perfectly honest, I'm still thinking about how we might achieve both goals that I've articulated, which is first, make sure that the default is really towards discharge, except that where there is a specific curriculum that's been required, the completion of that curriculum is necessary. I think I'm sure we can do that. I just have to think a little bit more about the language, and I'm sure others here will have similar, have suggestions on that line. That's my only real substantive comment on this. We support the goals broadly, and I'm happy to answer any questions on it.
I have a question. Mr.
You're
Chair.
muted, Dick.
I was there talking and just having a grand old time. David, and I think I'll probably ask everybody the question: should all offenders with probationary sentences be eligible, except those who are sentenced to a term of probation until further order of the court? Because you can never determine what the midpoint is of further order of the court. And what do we do with those folks?
I think that people have been, obviously it can't be a midpoint review as a matter of logic, as you correctly point out. That being said, I still think that there should be an opportunity for a review that the department conducts at some point. And I have not thought about what that might look like, to be perfectly frank, but I think it would make sense, and it would be in the spirit of this legislation for there to be at some point some sort of review that the department conducts. And I can certainly come back to the committee with and talk with some of the other stakeholders about what that might look like. But it seems to me to be in the spirit of the policy change here that everybody gets a chance for a review at some point, and we can think about what the timeline might be for those individuals.
That's a good idea. What about all crimes? I mean, given what we just experienced with Good Time.
I don't think that the same, I say this with some trepidation, but I don't think that the same concerns are going to arise here. I'm sure that there will be some, but there's two reasons why I don't think that. One is that this is, as I understand it, well, so let me check on that. I believe this is a prospective change, but I could be wrong about that. I could be misunderstanding the intent. So let me reserve comment on that and let somebody else correct me on that. But the more important difference is that the very serious crimes that elicited a lot of concern under the good time issue, they are very unlikely to be determined by a probationary sentence. And so I don't think that some of the really intense concern and frankly backlash that came from that change is going to be as applicable here. And again, here there's still an element of discretion. The courts can choose not to give this. This isn't earned good time. Basically meant that as long as as this committee well knows, it basically meant that the time was going to accrue as long as somebody didn't accumulate the DRs, and that didn't necessarily mean that release was inevitable. Certainly, I think that's important to remember. But I think here we're really talking about mostly crimes that are not going to fall into the category that raised the most concern around earned good time, and again, courts retain the ability to make an assessment about what is fair and just in terms of the actual discharge. It's obviously weighted towards discharge, which we think is appropriate, but there is still a check there.
And Dale raised that issue, and the language is pretty clear and convincing evidence that the discharge is not in the best interest of the person, or that discharging the person will present a risk of danger to the victim of the offense or to the community. That gives me some comfort in the determination of whether to release someone. The court could determine by clear and convincing evidence that it's not in the best interest.
That's right. And again, we think it's fair for it to be weighted in that direction. And again, the very serious charges that created a lot of concern are much more likely to be incarcerative sentences, and it's going to be less relevant to this policy change.
Senator Baruth.
I'm just wondering about the chair's talk about the difference between a term and until further order of the court. And I'm wondering, I'm not really familiar with that phrase so much. Is there a generally understood set of cases that receive that until further order of the court? Or is that just at the discretion of the sentencing judge?
It's certainly at the discretion of the sentencing judge. And those types of sentences, as I understand it, are relatively unusual. I will defer. I couldn't sit here right now and tell you exactly where that is most likely to happen. And so I would defer to Defender General Valerio and Attorney Pepper on that question. I know that some cases that end up with long supervision are the multi-DUI cases. Those have been in the past often furlough, very long furlough type sentences, FSU sentences. That's obviously going to change, I think, with the recent legislation, or could change with the recent legislation. But that's the type of offense that might see very long supervision or indefinite supervision. But I will let Defender General Valerio and Attorney Pepper talk more about what class of cases. In my experience, those are unusual.
And then just to speak to the issue specifically of sex offenders and how they might fare under this proposed legislation. So when you talked about completing programs, curricular programs, or just programs in general, I think that makes sense. That means we wouldn't want to say, okay, you're actively completing, but we're going to let you go halfway through. For a sex offender, if they're assigned programming, what does that typically look like in terms of time limits? Is it a relatively short program, or is it a program that lasts their entire probation period, or how does that generally work?
Again, I think there's others here who
Oh, okay.
will answer that much more precisely than me, and I'd turn it over to them. I mean, my quick answer is that it's usually in the neighborhood of like a year, 18 months in terms of that type of programming. That's
Okay.
my experience when I was practicing in court, but that's could have changed in the last few years. So I'll let maybe Mr. Crook can answer that. I see he's popped on. Right
Dale,
now.
do you want to answer that?
Sex offender supervision really is driven by the offender's risk, and incarceration, it starts at 6 months of programming. In the community, it can last indefinitely. Depends on the behaviors. We do risk assessments. If they're not able to maintain and manage their risks or their behaviors, they could continue on sex offender treatment for an extended period of time. Generally, it's a couple of years, 1 to 2 years, depending on the risk and depending on the offense that we have on the offender. So it's not a clear, you have a 1-year program and here's the end date. It's really based on the progress that the sex offender is making in their treatment and programming.
So we could, if we were to reword it according to David's suggestion about not just currently successfully satisfying conditions, but also completing programming, there could be a way of, if somebody was assigned an indefinite program, they would not be eligible automatically, right? Because they would not have completed their programming, their sex offender programming.
See,
Does that make sense?
Yes, it gets really tricky with the language of the conditions and how they're going to be applied. I can understand where it's coming from. I think we want to make it straightforward for everyone, and I'm not sure there's a straightforward, easy solution for this. It could be something where you have a level of compliance with the conditions of supervision and the completion of criminogenic needs or risk services or something of that nature. So you're really taking care of the behaviors or the concerns or the needs that got the offender under supervision in the first place. And it really starts getting complicated. Really, the conditions that are set are really important how they're worded. For an example, and I've seen this before, there could be a probation condition that says not eligible for early discharge as a probation condition, and that would kind of circumvent all of this by that probation condition. So there's little things like that as to the language and how it's written and how you want the department to apply the satisfaction of that condition. I don't really have.
I think if I might just kind of make an administrative decision here, we're planning next Thursday to come back to this bill. And I would ask that the witnesses and those that practice this and men to take a look at how do we deal with people who are ordered until further order of the court and don't have a term probation. Give it some more thought, and just trying to work off the top of our heads isn't always the best way to get there. And I think maybe that would be give it almost a week to look at this issue, decide how we want to deal with it. That work?
That works.
Other questions for David? David, thanks. We look forward to seeing you next week. And when
Thank you, Senator.
Take this up again and look at that. But also some thought about if there's certain crimes that we want to exclude from the list. All right. Thank you. James Pepper is next, representing the state's attorneys. There he is.
Am I coming through?
You're coming through, but it's rather weak.
Okay, let me get a little closer.
That's better.
Okay. So just with respect to S-445, the state's attorneys reviewed this bill, and I think all of them, without exception, want sentencing, including probation, to be evidence informed. I think that CSG has given us a lot of good data that this has led to a reduction in recidivism. They want terms and conditions tailored to an individual's risk. And we really do want a bright line incentive to give people motivation to comply with their conditions and to do well on probation.
I think I'm having a hard time hearing you. I don't know if it's on my end or your end.
Okay. Let me see if I can change up my technology.
On his end.
He's gone.
Maybe trying to get back in. The days of Zoom.
I will say, I think given what we've been talking about with earned time, this one seems to me, although I took David's point that it was a little different, I think the victims groups might wind up seeing them very similarly, for what it's worth.
Yeah.
Is
Okay.
this any better?
Oh, God, a million times better.
Okay. Well, then let me just start over then, if you don't mind. I apologize to the other witnesses and to the committee for the delay.
No, please do.
So the state's attorneys, just in general, want sentencing to be evidence informed. They want terms and conditions tailored to an individual's risk. And I think what this bill importantly does is creates a bright line incentive, a goal date, to motivate people to comply with conditions and to do well on probation. What you've heard from the other witnesses, and certainly all the state's attorneys, to the last one of them, agree that rehabilitative programming must be completed prior to release or discharge, which I think actually can be relatively easily resolved in this draft on page 6, just to indicate that rehabilitative programming must be completed, or risk reduction programming, or however we want to phrase that. But I'd like to just quickly touch on a point about conditions that are specifically tailored to supervision. So one of the most common probated sentences that we see, and I'm just going to use Washington County as an example, is for high-risk DUIs, which would be 5 to 180 days to serve, all suspended with 1 year on probation. So the stick would be that if you screw up while you're on probation, there would be a 5-day minimum, and then you'd be released on furlough. But that is specifically tailored to allow the high-risk DUI offender 6 months to complete the IOP, the intensive outpatient programming, and then an additional 6 months of sort of interlock or supervision to ensure that that individual, that the intensive outpatient programming is actually working. And so what this proposal would do is say, after the 6 months, after the IOP is completed, that the remainder of the term would, if they were successful in completing it, would be eliminated or discharged. So that's a concern that was raised with respect to just kind of some types of supervision that would extend beyond merely the programming. Another concern that we have is respect to some of the no contact provisions, no harassment provisions with victims. And often what we'll see is that a victim will allow something like an abuse prevention order to lapse when someone is on a probated sentence, because there are these no contact provisions, no harassment provisions. And, I think the state's attorneys to a T have no interest in, imposing a curfew on someone, or housing restrictions, or, require frequent check-ins or drop-ins by probation officers. But we do have some concerns around victim notification and victim harassment that under the language, I'm not sure we're fully going to be addressed by a court having to find by clear and convincing evidence that there's no issue with a victim. So because it's kind of a binary choice for the court at the midpoint, which is either discharge the person from probation or not. And it's not look at the conditions, eliminate all the ones that aren't related to the victim, and modify the sentence. It's just discharge or not discharge. So I think having some flexibility there strictly for the victim conditions would be our recommendation. And I wouldn't mind if there aren't any. I mean, I'm happy to answer questions, but I would touch on the indeterminate sentence provision as well. And just quickly coming to mind, I mean, the common sentences that get, or the common convictions that get the indeterminate sentence, it usually follows a two-serve term, and they're usually for sex assaults, aggravated domestics, L&L with a child. All of those crimes have a statutory penalty, and you could use that statutory penalty, the midpoint of that statutory penalty, as the time to review.
I'm trying to understand the flexibility for the victim, where there is a active victim, and what you mean by that in terms of, would you change the clear and convincing evidence, or
So
how would you?
That would offer judges the flexibility, and especially if you tied it specifically to this kind of victim issue, that could be a preponderance. What you could also do is, instead of just saying that the court shall terminate the period of probation and discharge the person, you could say the court shall review the conditions and period of probation, discharge the person, reduce the term, or otherwise modify the conditions. Offer some flexibility as to what the judge could do at that midpoint review, other than just strictly discharge the person from probation.
Yeah.
And again, we are very much, I mean, the midpoint reviews are currently happening. And I think that when there are not victim concerns, and, I would again allow DOC to weigh in, when there are not victim concerns, the state's attorneys have all told me that they regularly stipulate to them. So I think when it comes down to straight programming being completed and no victim concerns, probation terms are being discharged at the midpoint.
Okay. Bryn, can you find out what Montana did about this? Can we check with CSG to find out about Montana, this issue of the victims and so forth?
I would defer to Bryn, of course. I did ask this at the last CSG at the last working group, the Justice Reinvestment Working Group meeting, and they did say that judges in Montana have the ability to modify probation at any time, which I think is true in Vermont. So, they would probably just deny, their answer was they would probably just deny the petition to discharge and then modify probation.
Okay, well, you've already got the answer that I was looking for. That's good. Thank you.
I think that this language creates a very strong presumption through clear and convincing evidence that it will be discharged.
Yeah. Well, that was the idea behind it. Other questions for Mr. Pepper? Thank you so much. And we'll be back. Matt Valerio.
Thank you for having me. Matt Valerio, Defender General. We are happy to see this bill, and seems like it's come quite a long way from the original concept, and in a positive way. I'm happy to see that the Department of Corrections seems to be embracing the concept. I am, in going through the bill, I didn't have very many particular concerns, and more of the comments that I have arise out of the comments that other folks have had along the way. I'm intrigued by the department's suggestion that perhaps it wouldn't be a judicial review, but a administrative review. And I actually think that we might end up with better results for the clients with an administrative review than with a judicial review on discharge. If the same criteria are found, of course, if the person who seeks discharge from probation is denied by the department, then the Prisoner's Rights Office would have jurisdiction to challenge that review by Rule 75 review, which they do with any kind of administrative action. If it went back to the court, I'm anticipating that Judge Grierson may not want to add more hearings or more, anything more to the court's plate. This is one of those times that I will say that no matter which way this goes, whether it's an administrative review within the Department of Corrections or a review by the staff offices, it's clearly going to add work to the Defender General's office. But this is the type of work that we would welcome, even though it is going to be, some measure more work than what we have now. I mean, probation is the largest, kind of classification of people that we have in the custody of the Commissioner of Corrections, and it has been and continues to be one of the feeders of the incarcerative custody portions of of folks who are in the custody of the Commissioner of Corrections. But our job is to try to get people onto living a orderly and industrious life, as corrections likes to say, and part of that is getting them out from the restrictions that probation typically puts on people. I'm interested in how this might come out from an administrative versus judicial review of what goes on. There was some comment on the DOC's failure to pay fines, fees, and restitution should not result in a violation. And in fact, I believe that is what they do now, because it's unconstitutional to hold somebody, to put somebody in jail for failure to pay a debt. So if somebody is on probation and the only thing that they have is a fine, fee, or restitution, they might be able to violate the probation, but they couldn't incarcerate them anyway. The restitution, as you probably know, is a civil judgment that's subject to collection by the restitution unit anyway. And all of these things, fines, fees, restitution, Defender General copay, are subject to tax and lottery intercept to be satisfied, among other collection efforts. The Defender General's office doesn't have wage garnishment and supplementary process, but the restitution unit does have the ability to do that for restitution. So I think that the whole issue of collecting money from these folks is not really one that should be a consideration in whether or not they're discharged from probation. The question that has come up, which is interesting, and I'm happy to address, is the whole issue of, what happens on page 6 if it remains shall, and does this include sex offenders and domestic violence cases and other unsavory type cases that get a lot of publicity and victim input. Usually somebody only ends up on a probation with a further order of the court under a number of different circumstances. One is the person has a long history of criminal activity. So they might not be a sex offender or domestic violence or, a serious aggravated assault or something like that. But they might have a record that goes back decades, or 5, 10, 15 years, and they keep coming back on the same kind of stuff, property things, and they're either generally antisocial or they have a drug problem or mental health problem that prevents them from complying with the law. And those are people who will get a probation even on many misdemeanors or minor felonies until further order of the court. The other thing, though, and this is important, I think to know, is that there are those cases that are very serious crimes, but they have proof issues. And those people also end up with no jail sentences at the beginning with indefinite probation. So you will see it in sex offenses. You will see it in aggravated assaults and domestics and the like, where there is a problem where the state doesn't have a good witness to prove the case. And to get that person under the custody of the Commissioner of Corrections, there'll be an offer with a low minimum, all suspended on probation. And it might be a 1 to 15, all suspended on probation until further order of the court, whatever the conditions are. And those are ones where basically the state has difficulty proving their case, but they make an offer basically that the defendant can't refuse from a risk management standpoint. Now, oftentimes those deals end up very bad for the defendant because once you're in the system, it's pretty difficult to get out of the system with certain types of crimes. But all the defendant sees is no jail deal, I'll take it. Oftentimes it's better to take a jail deal and not be on probation indefinitely. Nevertheless, that's one of the other reasons why you can end up on until further order of the court, indefinite probation. They also occur with people with complex needs, people who have mental health issues, but they aren't bad enough to be deemed incompetent to stand trial. So they get indefinite probation orders. And the idea is that the state is going to give them a lot of wraparound services. Unfortunately, that's one of the big issues we grapple with in the criminal justice system, is getting people in with mental health issues who, while not incompetent to stand trial under the criminal legal standard, have severe issues that need addressing, and usually our criminal justice system isn't good at dealing with that. Of course, you also do have the sex offenders who will have the indefinite probation, although they don't necessarily have to. And the multiple repeat DUIs, and then there are those who, for some reason, even though their crime is not at the highest level, it's not at the lowest level, but they somehow present as dangerous or extraordinarily needy in some way, such that their likelihood of reoffense is likely. So as a result, they end up on probation until further order of the court. I think that with all of those situations, people who have experienced judges prosecutors and the like who have experience with these types of people, when the individual comes up for midpoint review, those are exactly the people that the statute is designed to pluck out and say, this person presents a danger to a victim or to the public, and they should not be discharged from probation. All of those folks who I described, I think, probably touched a nerve in anybody on the committee who's listening to it and says, yeah, well, I understand. Those are the ones that the judge or the department are not, whether it's administrative or judicial, are not going to let out under the proposal in S45. One of the other things that I'm always concerned about, it comes up in a lot of different areas that we've been talking about post sentencing, is the way our sexual assault statutes and L&L, the child statutes, continues to treat minors who are engaging in sexual activity under the age of 15 with their contemporaries in school. And I, again, repeat my call for us to address that issue so that you don't have 16-year-olds who have sexual activity with a 14-year-old being subject to the adult criminal system and being labeled sex offenders in the adult system. Similarly, even 17-year-olds with 14-year-olds and the like, basically people who are going to school together, who are engaging in this activity. And, this was part of a negotiated resolution of the so-called Romeo and Juliet time gap that this occurred during the Douglas administration. And I watched that unfold. But, it was very much like, when you're eligible for deferred sentence over the objection of the state's attorney. Some people wanted unlimited, some people wanted it age 21, and we came up with age 23 at some point. A very similar kind of thing went on with this. And I think we have to recognize at some point that we do have minors engaging in consensual sexual activity, and they're not sex offenders because they do it. But under our laws, you can be labeled a sex offender with an indefinite life probation, an indeterminate life sentence, with registration requirements going forward. And I think you've got to deal with that whenever you talk about these probation or early parole, release, all of these situations that we're talking about now. I do think that it's also important to realize that we talk about the midpoint review of individuals. What do you do with midpoint review for individuals who have a indeterminate life sentence? A few suggestions that I have is to perhaps have the review at whatever their minimum sentence would be. If they've been on probation, say it's a 5 to 15, and all suspended on probation, maybe after 5 years, the review could be had, or 50% of whatever the max is, so 7.5 years. Of course, the probationer can always move for discharge on their own if they want to. There's always that. It exists today, but if you haven't done what you're supposed to do, you're not going to get very far. Nevertheless, the midpoint review for people with indefinite sentences might be one of those types of things, the minimum halfway to the max, something like that. I understand that state attorneys desire to want evidence-informed sentences and conditions based upon the individual's risk. And while there are things that are out there that provide evidence to inform sentences, we have to understand and continue to understand that risk assessments do not provide evidence of individual risk. Those don't exist. What risk assessments do is create a profile of like-kind individuals and how like-kind individuals within that profile respond in aggregate. They do not tell you about the individual risk of any particular individual. And that is exactly why these midpoint reviews are important, because you can have time on the ground observing what the person does. How do they demonstrate amenability to treatment? How do they demonstrate an ability to comply with the law and conditions? And it is a show me period you start to learn about that individual's likelihood of risk. The risk assessments, while they are an easy way to take away, give some cover for, judges, prosecutors, and defenders and the like when fashioning sentences, they don't tell you about individual risk. That's something we've got to kind of get away from the concept of, and then understand that the way we see individual risk is by what they do. I just wanted to make one comment about the current midpoint reviews. Jim Pepper always comes in and says, well, these happen all the time. And when I ask my people about them, they say some of them have never heard of them. Others say, yeah, we see them and nobody can ever remember them being granted. From the defense perspective, they're really a non-factor in getting people out of jail as they currently exist, or off of probation as they currently exist. So we feel that this bill is important, and I think it's gone a long way to satisfying the need to look at people as individuals and what their risk is at some point during the course of their sentence. Thank you.
I hate the mute button, but then if I say something I shouldn't have said while I'm not muted, I hate that too. Any questions for Matt? Matt, thank you very much. I think you've been fairly clear. I hope you'll be available next Thursday when we try to mark this bill up and make any changes to it.
Yeah, that's my plan.
Great.
Thank you.
Judge Gerson. Oh, I'm sorry. Senator White has a question of Matt, or did you have a comment?
No, I was just going to actually thank Matt for the comment that many people haven't heard of the midterm review. And I have had, since I've started this, have had calls from a number of people in Windham County who are on probation who have never heard of it at all and have never been granted a midterm review.
Well, my familiarity with it is in the juvenile system where they are held, but I think it's yearly, not necessarily. Either yearly or every 6 months.
6 months.
Every 6 months.
And then on one date, is it 12 or 18 that the case has to go to court for the review?
18 for court and 6 for administrative.
Yeah, right.
Yeah, these are adults. These are adults.
I understand that, but what I was hoping to accomplish here was to make this midpoint review similar to what the juveniles go through when they have to go to court, and DCF has to justify continuing supervision. Judge.
Good morning, everyone.
Morning.
Thank you,
I'm sure
Senator.
You're thrilled to have more cases come before you.
Well, of course, my ears perked up when Matt said something about the administrative reviews. I hadn't thought about that as an option, but I'm certainly glad to discuss it with him and other stakeholders relating to this bill. For the record, Brian Grierson, Chief Superior Judge. Most of the comments from the witnesses today have dealt with the latter section of the bill on page 6, but I'd like to go back, begin my comments, going back to the section under 251, the new section B. And I think more than anything else, I certainly understand the policy and the rationale behind the bill as a whole. But I think, like I think some other witnesses have said, it needs some clarification, or what I would like to think of as simplifying the process. And what I'm getting at is, I think it should be clear under B, if the commissioner, as I read it, the commissioner would be applying for discharge under 252 section D, the midpoint. And it says, unless the court determines by clear and convincing evidence that discharge is not in the best interest of the person and so forth. And I'll get into those conditions, but I think it should be clear that if the commissioner's office is seeking the discharge at the midpoint, that it is at that juncture, it would be upon the state. The state would have the burden of proof of these conditions. And I just think that needs some clarification. I'm concerned, and I've been surveying the judges to get a reaction. Hopefully I'll have a broader response by next week. But the initial concern is that this idea that clear and convincing evidence that discharging the person is not in the best interest of the person. I don't know. I'm certainly not familiar with that standard. It's not defined in the statute, but beyond that, I don't know. I can't imagine why it would not be in the best interest of any individual who's on probation not to be discharged, or why they would not want to be discharged. And I'm not sure that standard as it is undefined. And I'm not sure what the court or an individual judge would do with that. When I talk about clarification or simplification, I think if it's clear that the state has the burden of proof, I think it would make more sense to tie it to specific reasons why the discharge should not be granted. And I'm referring to the latter condition, the second condition, and that is clear and convincing evidence that the person will present or continue to present a risk of danger to the victim or the community. Or, as many of the witnesses have been talking about this morning, the idea that they have not completed a specific programming. That would be two criteria that I think, if the state can satisfy the court under either of those prongs, that would be a reason not to grant the discharge. I think the first clause about not being in the best person's best interest is too vague in my opinion. I think it's interesting, and I'll be glad again to talk with the other stakeholders involved in this process. The idea that if you come in for a discharge, and let's assume that the state meets a burden, or the threshold burden of that the person shouldn't be discharged, would it be appropriate at that time to consider a modification of the probation conditions, not the sentence? I think there have been other bills and other discussions about modifying sentences after at this point, statutory 90-day period. But it may be worth, and I would certainly consider the idea of perhaps if a person is not entitled to discharge at that point, that perhaps some of the conditions of probation should or could be modified. And I would be glad to talk with corrections as well as the other parties involved around that issue. It may be an appropriate time not to revisit the underlying sentence necessarily, but the conditions that were imposed. So I would offer those comments with respect to that section, and if the committee would like, I can draft some language around those proposals.
Yeah, that would be helpful. But I think we'd all appreciate hearing that on next Thursday. I'm curious about changing conditions. It's been a long time since I've seen a probation condition order. So I'm sure it's changed some.
Well, I think some of the
Usually they're pretty standard, aren't they?
But they are, that's what I was going to say, that there are two types of conditions. One, there's the standard conditions that you probably wouldn't want to modify because that's how the department supervises individuals. But there may be special conditions that they have complied with and no longer have to be part of the sentence. And I think, as one of the witnesses said, once the person is under supervision, the department may, in fact, through their supervision, discover other issues that need to be addressed. So it isn't necessarily taking away conditions, but modifying the conditions to tailor the programming for what the individual needs. There may be something that they have learned, discovered over the course of supervision that was either unknown or not contemplated by the parties.
Questions for Judge Gerson? Senator Nitka, did you have a question?
Oh, no, thanks.
Oh, I'm sorry. These Zoom
I
things.
will just add that along with the discussion about folks who are on probation till further order of the court on sex offenses, and as Dale pointed out, those requests for discharge do not come in from the department. They are generally filed by the individuals without benefit of counsel because they're not entitled to counsel at that time. It's rare. I'll put it this way. It's very rare to have counsel represent an individual, and the department takes the position that they do not take a position on either favoring discharge or not. And so they become very difficult. There's very little real evidence other than the individual saying, I've been on for whatever, 15 or 20 years. And it becomes difficult for those reasons. In other words, some of the most serious cases we have in the department's hands are effectively tied by not being able to take a position, which I think leads to inconsistent decisions by the court, or could lead to inconsistent.
Thank you.
All right, thank you.
Our next witness is Chris Fenno, and Chris, welcome.
Thank you. For the record, Chris Fenno from the Vermont Center for Crime Victim Services. I want to thank the committee for inviting me to weigh in on this particular bill. I have talked to a couple of people this past week about it, and I wanted to start with the easy one because, again, the idea of restitution came up, and that's really not an issue for us. Whoever said it, I don't know if it was Pepper or Matt, that in fact, getting off of it currently does not require the full payment of restitution. And that is in fact what the restitution unit is charged with collecting. And so they will do that. There might be a restitution order that actually gets negotiated for payment plans or those kinds of things, but it is not a barrier to getting off of probation. And it was true. We do collect lottery winnings, tax returns, those kinds of things for the state. So looking at the bill itself, many of our concerns, and I appreciate that. I think that when people come back next week, a lot of these are going to be addressed. And I would second what Pepper's testimony was, and that is that we have some, and many people said this, we have concerns that if there is a program they are doing, that it must be completed. So, it just makes sense. You wouldn't want to, because it won't be completed if somebody is taken off of probation. We have concerns, and one thing I can do between now and next week is have a conversation with the network and actually put out a question for how much are they seeing that victims of domestic violence are not continuing their protection orders if they have one, because they're not going to be able to be, it's moot because they have conditions on their probation already. And so I am unaware of how big an issue that is, but it is an issue if people aren't going and getting those renewed, and they need to have them. So that is one concern. And the other is around notification of victims to victims that this probation is ending, because a lot of victims look at what the sentence was, they look at what the probation was, and they do the math. So just wanted to make clear how or what notification was going to happen, or even if it does happen, about an offender being able to, at the midpoint, get off of probation. Those are really the issues that we had. And as I said, I'm planning to talk to some more people, and maybe the victim advocates in the state's attorney's office, to just get a feel for what they think this might be the impact. And I can certainly come back and talk about that.
Good. Maybe we should actually, for next Thursday, invite the victim, the network against domestic violence and sexual assault to testify on the bill.
I think
But
that's
also to have, if Pepper, if you could take a look at how Judge Grierson's suggestions might work, where up to the state to, and also maybe if you want to get whoever would represent your victims advocates within the state's attorney's office. I don't know if there's somebody who represents them or if you do.
I might speak to that, Pepper, and that is that we, out of our office, we actually do weekly updates to the advocates so
Okay.
they know what is happening.
All right. So if I would like to invite the Network Against Domestic Violence, Sexual Assault. Just like, I'd like to have the network here next week if possible, Peggy, and also perhaps you could represent at that point the victims advocates and what you hear from them.
Yes, and I can certainly ask them if they have somebody they would like to have testify about this, and get with Peggy. If I can send her an email if they do have somebody they want to have speak.
Other questions for Chris? Thank you very much.
Thank you.
Bryn, can we just summarize where we're at before we take a break? Because I may have lost track of where we're at. We've had a lot of good suggestions, but some of them might not be as good as others.
So it sounds to me like the witnesses are going to get together in the next week before you take this up again next Thursday, and come up with some suggestions for the committee on a few issues. I can talk about the ones that I heard.
Yeah, if you would, please.
Sure. So I heard that there was some conversation about the review being an administrative review as opposed to a judicial review. You also heard testimony that perhaps the review should be at the minimum sentence as opposed to the midpoint, or perhaps the midpoint of the maximum sentence.
I thought that was the midpoint for those ordered till further order of the court, what the midpoint of the sentence would have been.
I think that's right for indeterminate sentences.
Yeah.
Right.
But I still think people should go before the court, whether it's the state presenting it or any opposition, or who determines whether or not, if you continue the clear and convincing standard, And that, I don't want to lose the courts, the person coming before the court saying, yes, we believe you've completed, and thank you very much, Mr. Jones. Hopefully you'll continue, we're going to release you from probation now, and hopefully you'll continue to do well. I think there's a certain impact there for the offender, and I'd hate to lose that. I also think that if the person shouldn't be released, it's always nice to have the judge say, based upon the argument from probation and parole, we don't think you should be released. I've always found that my experience with kids was it was pretty effective having the judge tell them, even if the judge just agreed with what the state was proposing. That's just my personal.
Okay, so I'll keep reviewing the suggestions that you heard. I think that you heard sounds like there's some consensus around defaulting to discharge unless there's required programming or curriculum that needs to be completed. And then that rehabilitative or risk reduction programming would need to be completed before the person is discharged. Sounds like there's some consensus about that.
Yep.
And then you heard that I think there was a suggestion from the department that rather than having the review take place every 6 months, if a person is ineligible for discharge, have the department review the person anytime the probationer completes a condition of probation.
Yeah, we were trying to avoid unnecessary work for the department, but if the department's willing to do that, I think that's fine.
It's too much.
And then you heard some, we heard from the department about changing that participating in the case plan to some kind of language about completing the conditions of probation, or in some way make that driven by conditions as opposed to a case plan. And it sounds like there may be some suggestions coming about what appropriate language is there.
Yep.
And then you heard from Judge Grierson that the language about best interest, the court making a determination about the best interest of the person, that's pretty vague, and we may need to get more specific there. And also,
yeah, I think Judge Grierson made a good point of, I didn't pick that up when I first read it. Discharge is not in the best interest of the person. Maybe we need to, I didn't pick it up when we first drafted that. That's my fault.
and then also, I believe he offered a suggestion that the sentence be modified if the person isn't eligible for a dismissal or a discharge at that midpoint review.
I think he said conditions be modified.
Right, rather than modifying the sentence, modify.
Rather than modifying the sentence.
Right. And that is I think that's mostly what I captured.
I think you got everything. Got more than I thought was there. Joe?
Yeah, I don't know if I was the only one concerned, and I don't think you spoke about it, Bryn, but the phrase "or attain goals" as matched up against completing or satisfying probationary conditions, I thought that was bringing some confusion in, and I heard Dale Crook say he agreed with that. I don't know if anybody else had that same concern.
Yeah, I think that kind of ties into what we were just talking about, Judge Grierson's suggestion, because as you know, that's an existing law that either attaining goals or completing certain conditions can lead to a partial reduction or a deduction from the remainder of the person's term. So it sounds like there may be an idea to move away from that changing of the underlying sentence and instead reevaluate the conditions.
Yeah, I just don't want to leave it so that probation has it in its authority to pick and choose between those two things. And while I agree the judge brought up a good point, I want us to be clear about the message we're sending to probation about what their obligations are. And I used an example earlier of probation saying, well, yeah, you've met your conditions, but we don't like the fact that you're going to be couch surfing. To me, that's a goal of probation, but it's not a probation condition as ordered by the court. So I want to see if we can't clean that up somehow.
Others? So just so we can, we got a couple of minutes and I'm going to have a little longer break than we intended. I wanted to make clear what I'm talking about. Next Friday, you're going to see on the agenda an item, and many of those that are in the room right now will also be invited to testify or to join in the discussion. Aggressive behavior of juveniles, danger to staff. That subject may not describe what we're really looking for, but I am increasingly concerned about the aggressive behavior of some of the juveniles who are in the system. We touched on it a little bit this week, talking about the covered bridge treatment program. But I've heard from a number of, particularly yesterday, talking with Pepper and John Campbell about some of the cases they're seeing and the inability. We discussed briefly the case where the child wasn't able to be transported to a program because there were no sheriff's transport wasn't available, and two caseworkers ended up supervising the kid in the motel, and one of them got assaulted. I think that it's important that we talk about this and that we start to look to the Department of Children and Families, but also the Department of Mental Health and the Department of Aging and Disabilities as well about this problem. Before it ends up being some kid who's 18 who's now continuing in the juvenile system, and there's no place for that child. And no, I just want to get ahead of the problem and not be behind it. Senator White?
We've been asked to take that up by VSEA in government operations because we deal with state employees, but I think that it's more appropriate.
You mean the case of the assault, or?
Yeah, the assaults and how we're going to deal with that in terms of state employees. But I think that it's more appropriate to have the major conversation here, and then if there's anything we need to do, we'll follow your lead.
Thank you. Yeah, I don't think, I mean, the fact that the reason the two caseworkers were forced to deal with a child in a motel room was because transport to Bennington wasn't available.
Right.
So if there were a problem that we should be looking at, we should also be looking at why sheriff's transports aren't available.
Yep.
The opening was there. Fortunately, that happens. For those of you who are still here, and I had invited Marshall Paul, but Matt, you're welcome instead. But I think we need to have this discussion.
Senator Sears, look what I have for you.
Oh my God, great. Thank you. Thank you. You were able to get into the Judiciary Committee room?
Yep, they're open. And if
If
they're
my
not
chair
open,
fits in your car, could you bring it down?
sure. I can do that.
That was a joke, folks. Okay. Anything else before we take a break? And we're going to hear from Dr. 1045. I lost his name here.
It's
Dr. Dr. Sexton regarding S30, the bill that prohibits firearms in childcare facilities. Okay, thank you. We'll get back at, try to get back here a little before 10:45.
Okay, shut your video and audio off, guys. Thank you.
Oh yeah, thank you all.